Thank you, Madam Clerk. Good afternoon, folks. We've got 4 cases. This is the afternoon session of the September docket for the Tennessee Court of Criminal Appeals here in Nashville. My name is Robert Wiedemeyer. I live here in Nashville. My colleagues to my right, Judge Robert L. Holloway, Jr. from Columbia, Tennessee. To my left, Judge John W. Campbell, Sr. from Shelby County, Memphis, Tennessee. Each side has 20 minutes to argue. If you represent the appellant and you wish to reserve part of that 20 minutes for rebuttal argument, let us know when you approach the podium here to argue. And we have read your briefs, so we're familiar with the cases to that extent. Obviously, the records will be assigned, and we'll be looking at those as well. We may have looked at part of the record, but we definitely have read the briefs. Any preliminary matters?
No, Your Honor.
All right, thank you. Call the first afternoon case, please.
State of Tennessee versus Anthony M. Standifer.
Good afternoon.
Good afternoon, Your Honors. Drew Justice for the appellant, Anthony Standifer. I'll reserve 5 minutes.
5 minutes, certainly.
And I've raised a few different issues in this appeal, and I feel like I should have time to get to all of them, but the first one I would like to talk about is sentencing. Since Mr. Standifer only pled guilty to simple possession, the trial court wrongly sentenced him to 3 years in prison. Here, the plea papers specifically have the elements of with intent to distribute crossed out. The plea transcript specifically calls it just possession of Schedule 1, and there's just nothing in the plea transcript to indicate that Mr. Standifer was agreeing to be sentenced to.
Let me stop you for a second, because when you read the plea transcript, the court said that he was pleading to a C felony.
Yes, Your Honor.
And he acknowledged that he was pleading to a C felony. And he sentenced him to, I guess, a total of 4 years diversion with 1 year supervised, 3 years unsupervised. Now, if his understanding was that he was pleading to a misdemeanor, then how did all this happen without somebody lodging an objection and saying, wait a minute, Judge, that's wrong?
Well, I'm not contending that he had it in his mind that he was pleading guilty to a misdemeanor. I guess what I'm saying is, in actuality, he did plead guilty to a misdemeanor.
Well, or else the paperwork was an error.
The paperwork and the oral plea transcript. I mean, ultimately,
The plea transcripts talks about it being a C felony. And the judge said it was 3 years sentenced and gave him a $2,000 fine, which is the minimum fine under a felony.
right.
So it seems to me that at what may have happened is there might have been a misunderstanding or could have been a misunderstanding, but shouldn't that have been raised in another vehicle as opposed to a petition to revoke?
I think there obviously was a misunderstanding because a C felony for this crime couldn't possibly exist. And the way the state tried to get around that below at the revocation hearing was they tried to just tell the judge, well, it was attempted drug dealing, not actual drug dealing. And there's obviously no mention of attempt in the plea colloquy or the plea papers. But to answer your question.
Okay, go ahead.
In terms of the only thing that would prevent this from being a vehicle where you can raise the error is just Rule 37 of criminal procedure, which talks about...
Or post-conviction.
What?
Post-conviction saying that the plea was not entered knowingly and voluntarily.
What I'm saying is, yes, you could definitely do post-conviction, but what I'm saying is there's nothing stopping you from raising it on direct appeal other than possibly Rule 37 of criminal procedure. And
Go ahead.
That rule says that you can appeal any issues unless you've waived them by the guilty plea. The case law talks about different types of errors, and under the category of fatal errors, that's something you can't waive even by pleading guilty or otherwise. And the reason you can't waive them is because they're errors that go to the court's very jurisdiction. And if the court simply put does not have jurisdiction to sentence you to 3 years in prison when you've just pled guilty to simple possession.
But then everybody heard what the judge said. Nobody said anything. Then you have a revocation hearing that occurred prior to this one, maybe like a year or so before this one. Again, nobody said anything about it being a misdemeanor plea. And the court didn't revoke his diversion that made him do 120 days, if I remember correctly. And he was continued on supervision. Nobody said a word about it then.
Correct.
In fact, nobody says a word about it, from what I can tell, until the very end of this hearing, when the judge is sentencing, and I think you made the comment that he has to be sentenced to a misdemeanor.
I think that's right, but the point is, the parties can't just by their silence or by consent or acquiescence, they can't confer additional jurisdiction on the judge from what the legislature and the Constitution have bestowed. And so if the legislature has not allowed the judge to impose a 3-year sentence for simple possession, then the parties can't just, by failing to object, give him that power. And so that's the basic problem. It's a fatal error because it goes to the court's jurisdiction. And frankly, if we were required to somehow raise this on post-conviction, it would sort of just be a waste of time, a duplicate of what we've already litigated. But again, the only thing that could conceivably prevent us from arguing it now instead of doing post-conviction is Rule 37. And as I've said, Rule 37 just doesn't allow for a waiver of this type of error. And then for my other issue or set of issues, it goes to basically whether it was even correct to revoke the diversion at all. Here, the basic problem is the evidence was insufficient to revoke the probation because all the evidence that the court heard that even went to the topic of what he supposedly did wrong was admitted only for a limited purpose. And this issue is a little bit confusing just because the state charged him with a multitude of different violations, and then in the court's oral ruling, it even purported to find him guilty of, a couple of things that he wasn't even charged with. But beyond that, most of that multitude of things he was charged with, most of them the state didn't even try to prove. What the state did specifically try to prove was that he had left the state without permission and failed to report during a couple of those times. The problem, though, is that the only evidence that the state tried to introduce was these different law enforcement reports, these probation reports from different places, I believe from Illinois, and I kept objecting that these are hearsay. The judge never did make any finding that they were reliable or any of that stuff, but and seemed to make a finding that they weren't reliable. But in any event, he ultimately said he was only admitting them for the limited purpose of just showing where these different jail records and probation records just admitted for the limited purpose of showing where Mr. Standifer was basically located on different days. And the problem with that is just showing where he was located doesn't necessarily prove anything because he would have to be located there without permission. And one thing I argued also is that rule, it's not real clear that leaving the state for a vacation even violates probation anyway. The rule, in context, it does talk about leaving your county or leaving your state, but in context, it seems to be talking about setting up a residence in a different county or state. So it's not real clear that like a trip would necessarily even violate the rule. But in any event, the state did not introduce any competent evidence that Mr. Standifer failed to get permission for these different trips. And without that evidence, with these different reports just being admitted for a limited purpose, there simply was not sufficient evidence to find him guilty of those violations. Like I said, there were some other things he was charged with, namely picking up new charges, committing new crimes. However, there was no proof introduced that he actually committed those new crimes. There was just proof that he was seen in jail after having been charged with those new crimes. That's not sufficient. I think at one point the judge said that he had failed to pay his fines, but there's absolutely zero evidence of him failing to pay any fines or fees. So ultimately, there was insufficient evidence and the probation should not have been revoked. And then as a sort of the flip side of this issue, or as an alternative issue as I styled it, I would say that if the court did introduce these different reports for a substantive purpose and for the truth of the matter asserted, if it did so, then the court erred because it did not make any finding of reliability and good cause as required by law and by due process. And I think the state has contended in its brief that maybe these could be business records or government records, but the rule in question specifically excludes law enforcement reports from those exceptions, and so the evidence would not have been admissible under any hearsay exception. And so with all that said, unless there are any further questions, I do ask that the judgment be reversed. And we would ask that the judgment either be reversed outright and the probation warrant be dismissed, or if that fails, we would ask for, I guess, a new revocation hearing, or we would ask that the sentence be converted to a misdemeanor. If for whatever reason it were not appropriate to simply convert it to a misdemeanor sentence, then we would alternatively ask that the plea be vacated altogether. But we would prefer, I guess, that it just be converted to a misdemeanor.
Mr. Justice, let me just ask you one, because I couldn't find it, but possession of Schedule 1 for resale is what class?
I believe it's a B.
B, okay. And you said there's no C that would involve Schedule 1, is that what I understood?
Not that I'm aware of, unless it's a facilitation or an attempt.
Or attempt, like the judge tried to make it.
Right.
All right, thank you.
Thank you all.
All right, thank you, Mr. Justice. General? Good afternoon.
Good afternoon, Your Honors. May it please the court. Alan Groves on behalf of the state. This court should affirm the trial court's revocation of judicial diversion for two reasons. First, the defendant was ineligible for judicial diversion, and second, because he violated the conditions of his diversion by failing to report to his Illinois probation officer and by leaving his state of residence without permission. The state does suggest that this court remand the case, however, for resentencing, because the trial court imposed a felony sentence immediately after the revocation of judicial diversion without holding a separate sentencing hearing. So
What is your position about what the sentence should be?
So we've suggested in our brief that this court should remand for resentencing and direct the trial court to either impose a 1129 sentence for a misdemeanor of simple possession, which is what the plea paperwork reflects that he pled to, or allow the state to move to withdraw the plea.
All right, let me ask you this. If that's the state's position, then why is this not moot?
Why is what not moot?
Well, if it was 1129 sentence, we've long since passed the time that would have expired, because the first violation report didn't come down for like 2 years. So after 11 months and 29 days, if there was no violation report, this would have been over with. It was the end, the diversion was over. If you're correct in that, then this is a moot point, isn't it?
That's true. If the state is not allowed to withdraw the plea, if the court doesn't set
It
aside.
seems like it's too late now if in fact it was a misdemeanor.
Well, it's not moot. This court routinely will order trial courts to correct a judgment so that the judgment properly reflects what the conviction and the sentence were, even if it might require a defendant's immediate release upon entry of that amended or corrected judgment. So I don't think the issue is moot. And it certainly couldn't be moot if the state still has the opportunity to move to withdraw the plea, which the trial court could clearly do if there's not a final judgment on remand.
Do you know how the trial judge could have gotten to a C felony on these charges other than an attempt, which I don't talk about an attempt?
That's the only way, Your Honor, that I could think of. And I think the defendant is correct in the sense that the plea paperwork doesn't mention the word attempt. There's no discussion in the plea hearing transcript that he was pleading to attempt. But I really think the court doesn't need to get bogged down on this specific issue, because if the court agrees with the state that the trial court erred by imposing a sentence in the first place without holding a sentencing hearing, then the court simply needs to vacate this judgment and remand. And the court doesn't need to decide whether this is an illegal sentence or not, because it's going to vacate the judgment, as it's done in at least 2 other cases that we've cited, Ketter from last year and the Votto decision. That's exactly how this court has handled previous situations. So I don't think the court needs to wade into the issue of whether this is an illegal sentence or not. I understand Your Honor's concern, Judge Campbell, about the diversion period being 4 years, and I did want to address that briefly in case the court reaches this issue. Under the diversion statute, 4035-313, it says that for a misdemeanor, the deferral shall be for a period of time not less than the period of the maximum sentence for the misdemeanor, which would be 1129. So it can't be less than 1129, but it doesn't say that it can't be more than 1129. And in fact, if it's for a felony, it can't be more than for the period of the maximum sentence of the felony. So I do think the defendant could have agreed to a longer diversionary period than on 1129. So I don't think that that fact in and of itself shows that this was necessarily a felony.
Well, I'm not saying I know everything, but in 40 years, I've not ever heard of somebody with a misdemeanor diversion going past 1129.
Well, it certainly wouldn't be in their best interest, but
Well,
a
no,
person
and
pleads.
then, like, I know that you can for like domestic violence cases, it can go out for like 2 years.
Mhm.
But for just a general misdemeanor conviction going past 1129, I don't think I've ever seen that.
Sure, and I acknowledge to the court this is a pretty unusual case procedurally, and there's obviously some confusion between the parties, and there's questions about whether there was truly a meeting of the minds.
Well, then that's the question I have is this the proper avenue to get into that, or should it be raised in another proceeding?
Well, the defendant was already on judicial diversion, and when he violated, the state was trying to revoke his diversion. So it's not that he was raising the issue. The state was the one trying to revoke his diversion, and then following the revocation, the trial court needed to impose a sentence. And so at that point, that's when the issue became live. And
Well, but it's the question, it seems like the issue is what he pled to.
at the sentencing phase, yes.
Well, I mean, even, the guilty plea was accepted in 2015. So it sounds like there was no meeting of the minds in 2015. Everybody seemed to think it was a C felony. At least that's what the paperwork shows. So, but now we're hearing that it should have been a misdemeanor. There sounds like there was not a meeting of the minds. There was some problem with how this case was understood by everybody.
I agree, Your Honor, and I think that's why if this court follows our suggestion to remand, the state could very well move to withdraw this plea. Because there wouldn't be a final judgment. Double jeopardy doesn't attach until the court unconditionally accepts that plea. So if the judgment's vacated, we're just back at phase 1. And in theory, the state could press the original charges and seek a Class B felony, which defense counsel acknowledged at the revocation hearing. And the trial court even initially said, is that what you want me to do, to start over at a Class B felony? And at first, defense counsel said, well, if Your Honor, if that's what we need to do under the law, that's what we should do. And then he kind of backpedaled and suggested, well, or you could just impose an illegal sentence, and we can go from there. And that's eventually what happened.
Well, doesn't Wooden say if the sentence is expired, we can't find it as an illegal sentence and give any relief? And if this is a misdemeanor, the sentence has expired. If it's not a misdemeanor, 4 years is an illegal sentence for the misdemeanor, or for the possession. It's just a mess. I'm not sure. I'm not sure this gentleman hadn't served his full sentence, and it needs to be dismissed or thrown out or whatever we need to do.
I do understand it's unusual, Your Honors, and that's why I think our remand here is the simplest solution, is the court doesn't really actually have to address whether this is an illegal sentence. If the defendant were to appeal again after a remand and a full sentencing hearing, if he was still dissatisfied with the sentence or thought it was illegal, he could then appeal again. But right now, that's premature. Because
Remand it back to the original trial court to determine if the plea was valid, not for the revocation. Is that what you're saying?
to remand for resentencing. So the court has, yes, we are asking the court to affirm the revocation. There were violations here, and in fact, the defendant was not even eligible for diversion because he pled guilty and was placed on diversion in 2015. The trial court found that he violated in 2018 and revoked him, sent him to the county jail for 120 days without imposing a sentence, and then purportedly put him back on judicial diversion, which you can't do. And just to be clear, we're not trying to collaterally attack like that order because we didn't appeal from that order, but it is relevant that the defendant is not qualified because he's previously been granted judicial diversion. So we're asking the court to affirm the revocation. We're only asking the court to remand for resentencing. But at the sentencing phase, because there is no longer a final judgment, the state should be able to withdraw the plea if it wants to and press the original charges.
But going back to what Judge Holloway was saying, which is what I was saying originally, is if he was put on diversion for a misdemeanor, after 11/29, I believe, I'm concerned that he completed that sentence before there was a violation. And again, I'm not aware of where you could run diversion on a misdemeanor out for 4 years.
So I'll just say to that point, right now he doesn't have a misdemeanor sentence. All we have is a judgment of conviction that shows a guilty plea to attempted possession with intent to sell or deliver.
That's on the new one that was just done.
Yes, that's all that's before the court, so the court doesn't need to get into whether he has served in 1129 or not, because that's not what's before the court.
So the trial court just found him guilty of something that would fit the sentence that was already given?
Yes, Your Honor, that's what the record reflects, and we do think it should go back down so the court can impose either a correct sentence or to set aside the plea as it initially offered to do during the revocation hearing, which I think would probably be more equitable.
Wouldn't do anything about it. So why don't we just dismiss it and see if the Attorney General does anything about it?
Well, it'd be up
Save
to the
those
District
steps.
Attorney General's office whether to pursue a Class B felony on remand. But we do think it should have that option.
I understand it's a mess. I think we all agree on that. And I don't know what to do about it.
Yes, Your Honors. If there's no other questions about the sentencing issue, I've already briefly addressed the revocation itself, but I didn't hear my friend on the other side address the eligibility issue at all today or in his reply brief, so I take it that that's uncontested. He's been previously granted judicial diversion in 2015. It was revoked. He should never have been put back on diversion, and that certainly should have been a factor that would support revocation the second go around. And if the court agrees with us on that, then all of these rule violations are really unnecessary to get into because that's an independent basis for revoking the diversion.
We could just as easily say he should have never been revoked because he had served his sentence.
Well, the court would have to leapfrog over a few issues to get there, which is why I think the remand, again,
More than the trial judge had to do to get here?
is necessary. We're acknowledging the trial court erred here, Your Honor. But if the court gets to the rule violations and, disagrees with us on the eligibility point, just wanted to make a couple points on the sufficiency of the evidence to support the violations. The defendant claims that on the rule about informing your probation officer or before leaving the state, that's not actually a violation, and I just want to dispute that. This is what the rule says. I will inform my probation officer before changing my residence or employment, period. I will get the permission of my probation officer before leaving my county of residence or the state. Those are two separate requirements. You are required to get permission to leave the state, and the defendant's simply conflating those two sentences of the rule. The second thing the defendant argued was that the trial court never actually admitted these progress reports for the truth that he did not have permission to be outside the state, but that's also just not properly supported by the record. And I'd point the court to volume 4, pages 27 and 28, where there's a dialogue between the trial court and the prosecutor, and the court specifically asking the state, for what purpose are you introducing these reports? He says, are you trying to introduce the report to show that he, for the truth of the matter, asserted that he committed those crimes inside the report, or just the fact that he was charged with the crimes? I guess, what is the purpose of it? The prosecutor says, we're not admitting it to show that he committed the crimes, just that he was there. And then the court continues. He was there without permission, and the state says yes. And then the court goes on to say, I agree. So the court did admit the reports both to show that he was outside the state and that he was outside the state without permission. So the defendant's argument is without merit on that point. On the admissibility of these reports, this is a due process issue, not a confrontation clause issue, because we're in a revocation posture and not trial. And we've cited this court's decision in the Gowana decision, which said that these types of progress reports from other states fall within the public records hearsay exception. I understand the defendant disputes that holding, and even if we grant them that, the Gowana decision itself also analyzes these progress reports under the traditional due process analysis of is there a good cause to admit these types of reports, and would they be reliable? And even under that due process analysis, it found them to be admissible. And this court also, in State v. Wall, which is a published decision from 1994, it said that even Tennessee probation reports are like the quintessential form of reliable hearsay in probation revocation proceedings. So these reports are going to be admissible either way you look at it, whether they're under the hearsay exception or whether they're hearsay and meet the Wade standard for being reliable. The defendant also just briefly referenced that the trial court mentioned unnoticed grounds in the revocation order, and that issue's been waived because he didn't argue that was a due process violation in his statement of the issues in his brief, and of course it would be harmless anyway because the court did revoke on properly noticed grounds. The court has no further questions. We do ask the court to affirm the revocation of judicial diversion, but to remand for resentencing. Thank you.
Thank you, General.
In terms of the what the reports were introduced for the purpose of, on page 28 of the hearing transcript, it says the court said that shows that he was there, and then the state said yes, and then the court said, I agree, I'm going to allow it to come in for that limited purpose, not that he committed the crimes outlined in the violation report, just that he was arrested in those various states. And so there wasn't anything about the judge saying I'm allowing it to come in for the purpose of showing that he, wasn't submitting to his probation officer, or that he was defying the rules about whether he's allowed to go on vacation to these different places or whatever. And I call it vacation. I think some of these trips, the evidence seems to show he was going for different, like, sports-related reasons for at least some of it. But so ultimately, it doesn't matter. Like, I disagree with the state's assertion that these reports should have been admissible broadly, but ultimately, that's a little bit beside the point if the judge did not admit them broadly, because, like, there's a rule that, let's say that the court wrongly admits some evidence in favor of the state, and then that evidence, if allowed for its truth, does render the proof sufficient to convict the defendant. The defendant's not allowed to appeal and say, well, the court wrongly admitted this evidence, and then if the court had ruled the right way on that evidentiary ruling, then the evidence would be insufficient to convict. So, in other words, when you look at sufficiency of the evidence, you have to look at what evidence actually came in and for what purpose. You don't go underneath it or behind it and say, well, was the evidentiary ruling correct? So it doesn't matter whether the court was right or wrong to limit the state's evidence. All that matters is that the court, in fact, did limit the state's evidence. Given that it limited the state's evidence, the proof is insufficient. And it doesn't matter if the state's coming up with these additional hearsay grounds or whatever. I dispute their hearsay grounds, but they're just a little bit beside the point. In terms of whether the defendant actually completed his sentence before the revocation, I would tend to agree with that, and I didn't have a chance to find it in the record, but I'm 95% sure I specifically made that argument to the judge at one point, but he just didn't agree with me and didn't let me get very far with that. So I would submit that since the judgment was for a 1 year, it was for a misdemeanor, that he should have completed his sentence before the revocation period. And frankly, even if we considered it a 4 year, like it said that he wasn't supposed to be supervised anymore after one, and there's not any reason to think that he failed to pay his fines or whatever that would have extended it beyond the 1 year. Now, the state's, their main objective in this hearing is to have this court remand to the trial court to have him just sort of redo what I contend was basically already done. The state says we needed a separate sentencing hearing, but, I mean, even though we didn't call this a separate sentencing hearing, we didn't wait 30 days in between the guilt phase and the sentencing phase or anything. I mean, we did do everything sequentially. We first found the defendant guilty, and then we had a separate session shortly thereafter to decide what the sentence was going to be.
Was there a pre-sentence report prepared?
No, Your Honor, I don't believe so.
There was no strong R assessment, which I think is required. I think both of those are required, aren't they, for sentencing?
I guess that's true. However, we didn't object on that basis, and nor did the state. I don't really see what the purpose of that would be, but no, I don't think we had one, and maybe we should have. But ultimately, as a practical matter, if we were to just remand this to the court without saying whether it was or was not a misdemeanor that he was pled guilty to, it seems like it wouldn't accomplish anything because the judge already pretty much rejected my argument on that, and so that's why we appealed to press it before this court. And then finally, under Rule 37 of criminal procedure, it specifically says that a defendant does get to appeal on a plea of guilty or nolo contendere if the errors complained of were not waived as a matter of law by the guilty plea or nolo contendere plea or otherwise waived, and if such errors are apparent from the record of the earlier proceeding. And again, in Cantrell versus Easterling, they talk about clerical errors, appealable errors, and fatal errors. Appealable errors you can generally waive by your guilty plea, but fatal errors you cannot. So for that reason, we just submit these issues are properly before the court. We would ask that Your Honors either convert it to a misdemeanor or dismiss it or do whatever you feel like is appropriate. Thank you.
All right, thank you. The next case, please.
Rodzell Lamont Mason versus State of Tennessee.